Good morning, and thank you for joining me on the path to liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the Fast Friday edition of the show for February 23rd, 2024. And I don't usually cover mainstream media idiocy, but man, this recent article that I'm talking about from CNN on the recently passed Utah Constitutional Sovereignty Act is a real winner, and it shows how both supporters and opponents of the legislation often just get it totally wrong. But first of all, just a quick introduction to what we're talking about here. From a report by Mike Meharry, Utah Governor Spencer Cox signed at the end of January the Constitutional Sovereignty Act into law. It formalizes a process in state law to end state and local enforcement of some federal actions. Those of you who are regular viewers or listeners of the show, you're very familiar with the idea of refusing to participate in federal enforcement on a state or local level. I'll talk about that, the legal doctrine of anti-commandeering on that in just a moment. So this law is just taking what already exists and creating a formal process for it in state law in Utah. And under that law, Mike writes, the Utah legislature has this authority to do this process. This is how they're going to go about doing it, to pass a concurrent resolution prohibiting a state or local government officer from enforcing or assisting in the enforcement of a federal directive, that's the term they use, within the state if the legislature determines that the federal directive violates the principles of state sovereignty. It's a process. They're saying, hey, you can do this, and here's how you can do it, and this is what you need to do to qualify. And here from the Constitutional Sovereignty Act, I've got the text here. It'll be linked to in the show notes. Alan Mosley organizes that, and I'll get it published in a couple hours after this live stream is done over at 10thamendmentcenter.com/path to liberty. But here in the Utah law, it says federal directive means, quote, a statute passed by the U.S. Congress. 2, an executive. So there's a few things. 1, a statute passed by Congress. 2, an executive order from the president. 3, a rule or regulation adopted by a federal agency. Or 4, an order or action by a federal agency, an employee or official appointed by the president of the United States. So just basically federal acts, laws, rules, orders, regulations, mandates, etc. They're just saying, hey, if we determine that any of these things violate the principles of sovereignty, of state sovereignty, then we can, if we want to, pass this concurrent resolution to say that no one in the state can help the federal government enforce it. And they say a federal directive, this is the standard that they're going to use. A federal directive violates the principles of state sovereignty if the federal directive restricts or infringes upon a power or right reserved to the state by the 10th Amendment to the United States Constitution, or the state's rights or interests to provide for the health, safety, and welfare and promote the prosperity of the state's inhabitants. So in their view, if they determine that a federal a program, a federal act, a rule, a regulation, executive order violates these principles, this line in the sand, it's a very gray area. It's up to them how they determine it. They can then pass this concurrent resolution and no one in the state can help the federal government enforce it. And they also specifically say just because we don't act on something, and this was pretty smart, just because we don't act on something doesn't mean we're implying that the federal act doesn't violate the principles of state sovereignty. Now, it should be pointed out that they did not need to pass this. They didn't have to pass it at all because they already have the power to do this. It's a reserved power to determine how to use their own resources. This is called the police powers. James Madison described it in Federalist 45. The powers delegated by the proposed Constitution to the federal government would be few and defined. Those reserved to the states are numerous and indefinite. And that's the broad swath of what they call the police powers. They can do basically whatever the people of each state determine that they want to allow their state to do or not to do. So they already have this power to determine how they're going to use or not use their own personnel and resources. And they don't have to help the federal government. If the federal government needs help from the states to implement their acts, they've got a different problem. Maybe they're doing too much stuff in the first place, and they're relying on the states to do the work that they want to get done. And that's how kind of they get away with doing a lot of extra stuff, is that they hand out a lot of cash to the states and they hand out goodies and they say, partner with us and you do all this stuff for us, and they can get away with implementing a lot more stuff. Now, Alexander Hamilton had a little something to say about this type of a process, whether you rely on the states or not. He hated the idea under the Articles of Confederation that many things required a positive action by the states in order to implement it. In Federalist 46, or Federalist 16, I'll get to 46 and Madison in a moment, he said, if the interposition of the state legislatures be necessary to give effect to a measure of the Union, they have only not to act or to act evasively, and the measure is defeated. Now, of course, he was complaining about that type of situation under the Articles of Confederation, and Congress couldn't get a lot of the stuff done that he had been pushing for them to get done for some time. But the important point remains, and Hamilton was absolutely correct here. If the feds need help from the states, then the states can just say, hey, we don't want to help you. They just choose to not do anything, or they act evasively, and they defeat the federal program. That's exactly what Roger Sherman said on the more positive end of the spectrum in December of 1787. This was just a few days after that Federalist paper from Alexander Hamilton was published. I'm not sure if Sherman had read it at that point. Maybe not, because it wasn't widely published at that point. But Sherman said all acts of the Congress not warranted by the Constitution would be void, nor could they be enforced contrary to the sense of a majority of the states, recognizing that the federal government, if it violates the Constitution, if it's willing to do that, it's not just going to back down because you tell it to. It will still try to enforce stuff. But if the majority of the states don't go along with it, then they won't be able to implement this stuff. James Madison had the same take in Federalist 46 in January of 1788. This is just like 6 weeks after Sherman, 4 days after Hamilton. And he advised a number of things for states and individuals to use, a number of tools to stop and defeat federal programs without relying on the federal government to somehow do what it never does, which is magically limit its own power. And he said states should use legislative devices. The people should refuse to comply, should use noncompliance, and states and people should use a refusal to cooperate with officers of the Union. This is what the father of the Constitution said should be done to defeat federal programs. Hamilton, of course, complained about that type of a process and tried to develop a system where the federal government wouldn't rely on the states in order to implement its stuff. But as long as it does, it's in a lot of trouble. And as we live under the largest government in history, it relies on the states for everything, which is why this is such a powerful strategy today. Now, even the Supreme Court, now, if we're talking about what the founders have to say, a lot of times modern precedent and practice, it totally ignores them. Very rarely do you find something in modern Supreme Court precedent, especially something that lasts over 150 years, case after case after case, they take the same position, which supports people like James Madison and Roger Sherman in saying that the states should just not help enforce, should not participate, use a refusal to cooperate, and that's okay. And this is called the anti-commandeering doctrine. It goes all the way back to the Fugitive Slave Act of 1973 case in 1842, Prigg versus Pennsylvania. The most prominent, basically it says that the Supreme Court has held over and over and over from 1842 through 2018 in a bunch of major cases that the federal government cannot require the states to do anything to implement or enforce federal acts or regulatory programs. The most prominent one that most people would know if they're mentioned this, lawyers tend to ignore it. If they don't, they're like, oh, dude, what was that? I know I should remember this from law school, but they'll be reminded in time as we keep pushing forward with this. Here's 1997, Prince versus U.S. The federal government may neither issue directives requiring states to address particular problems, nor command the state's officers or those of their political subdivisions to administer or enforce a federal regulatory program. It matters not whether policy making is involved and no case-by-case weighing of the burdens or benefits is necessary. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty. There's no dual sovereignty. The only sovereignty is with the people of the several states, but we'll skip over that for now. But basically, the federal government cannot direct the states to help them do anything. There is no such thing. Now, the most recent one was in 2018, Murphy versus NCAA. And here's just a quick clip from it. The anti-commandeering doctrine may sound arcane, but it is simply the expression of a fundamental structural decision incorporated into the Constitution. the decision to withhold from Congress the power to issue orders directly to the states. It is not there. The government is one of delegated and reserved powers, and there is no power delegated to the federal government to order the states around. The third Chief Justice, Oliver Ellsworth, said, this Constitution does not attempt to coerce the states in their political capacity. They cannot use this type of force to tell them to do stuff. Now let's get to CNN. I know you've been waiting. We can't even get past the title before it's absolutely stupid. Utah's new Sovereignty Act sets up a process to overrule the federal government. But is it constitutional? I mean, if you listen to what I just had to say here and you read the text of the bill, I only read you parts of it, there is nothing in there about overruling the federal government. It's not saying that the federal government's laws are not valid. It's not telling the federal government that they can't come in and do what they do. They're just saying, we're not going to help you. It says nothing about overruling anything. But here in the lead, the first paragraph, a bill recently signed into law in Utah sets up a process for the state to overrule or otherwise ignore federal rules and decisions, the latest move in a Republican-led push against what they see as federal overreach. Again, the legislation, the law says absolutely nothing about overruling anything. It is literally just a process by which the legislature year-round can have this concurrent resolution and say, we're not going to help the federal government. It's not about ignoring them. The federal government does not have the authority, as we can see, even the Supreme Court tells us. They can't tell the states they have to help them enforce federal acts. It's got nothing to do with anything that CNN is saying. If you can't see the difference between, we're not helping versus we're overruling, you're probably just being dishonest, and maybe the CNN article is awesome for you. Now, Governor Spencer Cox was quoted in this CNN article from the little brief quip that they put out on signing. And he also doesn't understand the Constitution or the anti-commandeering doctrine. He says on SB 57, well, the first part is good. Balancing power between state and federal sovereignty. Again, sovereignty is final authority, and government does not have final authority in the constitutional system that the founders and ratifiers gave us. The people of the several states hold final authority, and all governments are emanations of power from the people. That's it, period. So there is no such thing as state sovereignty or federal sovereignty, but, I'm not going to quibble over that too much. They say it's an essential balance. He's an essential part of our system. But, Cox says, this legislation gives us another way to push back on federal overreach and maintain that balance. No, it doesn't give you anything. That power already existed because you have the reserve powers. The Supreme Court has validated this for ages, since well before you were even dreamed of, Spencer. So you should know this. This is real basic stuff, and you're a governor. I'm glad you signed it. It doesn't give it... So Utah's not given anything new. It's literally just saying, this is how we're going to put it into practice. And it's not that it's a bad idea. I actually have generally not liked this type of legislation because most states that consider it say, hey, we won't do this. We won't help the federal government as long as maybe the attorney general or the government certifies that they think it's unconstitutional. They have this determination first that something is unconstitutional. And of course, if they do that, then the feds are going to come in and say, well, you can't say something's unconstitutional. Only the federal courts can do this. Strike it down, and then everyone's going to back down. It's going to be a big waste of time. Even though we can agree that everyone who takes an oath should have an opinion about constitutionality, again, a different story. So I do think it's actually a good version of this in Utah because they made it clear about how they're going to approach this strategy, and it can be used year round. I believe the Utah legislature is only in session for like 45 days, 45 legislative days. Maybe it's 30 or 60. It's a short time, which is good, but they can use this process year round rather than just when the legislature is in session. And you need something like this year round. If you want to get all the details of the process for that in and out of session, just read the legislation. It'll be linked to in the show notes, 10thamendmentcenter.com/path-to-liberty. Back to CNN. They say, yet the push may stand in conflict with the U.S. Constitution's supremacy clause, which states that federal laws take precedent over state ones, not those in pursuance of the Constitution. They don't say that part. Robert Kiter, a law professor at the University of Utah's S.J. Quinney College of Law, said he was skeptical the Sovereignty Act was constitutional. This guy is a law professor. He doesn't even know some of the most recent major case law from the Supreme Court, the anti-commandeering doctrine. Like, this guy shouldn't have a job, but he's being quoted as an expert. Quote, "This sends the message, and the Utah legislature is famous for sending messages of this sort, that it's unhappy with the federal government, and it's expressing that in a way that is constitutionally problematic." So if you think about it, if even the Supreme Court takes the position and agrees with the founders that the federal government is not authorized to tell the states to help the federal government enforce federal programs, and then the states just say, hey, we don't want to help, then there is no supremacy clause question for Utah. But the law professor just is not deterred by facts. They just want to push a particular narrative, and it's easy to find idiot law professors who know nothing about the law. Kiter, the law professor, CNN writes, said the bill is just, quote, symbolic for now. Well, maybe it is. It is certainly symbolic, because if they don't use it, it means nothing. It's grandstanding. If the legislature actually passes a concurrent resolution and overrules a federal regulation, there is no such thing in the law that says they can overrule. There is no process for it. They're just saying, we are not going to participate. Straightforward. Then it will likely be overturned due to the supremacy clause, he predicted. Well, Kiter shouldn't have a job. This guy is a complete fool. Here, the Supreme Court. Let's read what the Supreme Court says about the supremacy clause and anti-commandeering in the most recent anti-commandeering case, Murphy versus NCAA, May 14th, 2018. I'll link to it in the show notes. 10thamendmentcenter.com/path-to-liberty. The argument from the government in that case as well was supremacy clause. And here's what the majority said. Pointing to the supremacy clause will not do. Straight up, just saying supremacy clause is not enough. Since the Constitution, quote, confers upon Congress the power to regulate individuals, not states. That's the case that Alexander Hamilton was making. He did not want the states involved in implementing federal programs because that would create issues for implementation. It's reaffirming this. This provision at issue must at best be one that regulates private actors. So if the federal government is passing something, it says, okay, well, you can't have this tool of self-defense. This is not saying that the state has to go do the gun grabbing for the feds. But because they only have a certain number of employees and can only close a certain number of cases, the ATF routinely, almost constantly relies on state and local law enforcement to help them implement and enforce federal gun control. So again, the Supreme Court very specifically says pointing to the supremacy clause on an anti-commandeering case will not do. And this guy, of course, this law professor expert cited by CNN, who should be out of a job, but as long as the state is not actively interfering, is what they're saying, there is no supremacy clause question on this kind of stuff in the first place. And in case this wasn't enough, CNN has a little bit more. They want you to think of the Confederacy and slavery and racism. Here's how they put it. This is a debate going back to the original founders of the Constitution through the nullification crisis of 1832 to 33. When South Carolina tried to avoid paying federal tariffs, and into the southern states' attempts to avoid racial integration in schools in the 1950s. Now, of course, they don't ever mention any of the other ways that this type of tool may have been used, and they get a few facts wrong there, too. They don't talk about immigration sanctuaries. Of course, we know that during the previous administration, that administration tried suing in federal court over and over and over, a bunch of times, all kinds of immigration sanctuaries, and kept losing because the federal courts held, well, under anti-commandeering, you can't require them to do stuff, and they're just saying, we're not going to help you. And this has been reaffirmed over and over and over. The Prince case was on the right to keep and bear arms. We see it across the political spectrum. Of course, they also don't mention that. They don't mention the marijuana legalization, where states are using legislative devices not complying with federal, the CSA of 1970. So any case claiming supremacy that has come up in this type of a situation, they basically all lose very quickly. But if they reported on that at CNN, it would totally derail their racism storyline. Now, it wasn't just CNN. I got a couple other that I want to mention here before heading out on this long fast Friday. Here from the Deseret News, they quote Representative Joel Briscoe from Salt Lake City, who said, "This bill goes further than anything I've seen in my time here, whereby it provides a mechanism by which the state could prevent a federal agent from fulfilling a federal act." It's got nothing to, it doesn't say anything about interfering with federal agents. I know some of you out there would love to see states arrest federal agents, But that's not, it's strategically, it's not happening right now. What we need is to take this first step that James Madison told us to take, that Roger Sherman told us to take, and refuse to participate and encourage people to refuse to comply as well. So this is just an utter lie from Briscoe. It's a complete lie to say that it could prevent a federal agent from fulfilling a federal act. The federal agent is welcome to go out there without any backup and try to do a gun grabbing mission. But they never do that. They always rely on the locals to help them out. It's also Fox News. The local Fox affiliate, Ben Winslow, says Governor Spencer Cox signed a bill into law that allows the state to ignore some federal directives and orders. There's no such thing that the federal government is directing or ordering the state of Utah to do. And they're not allowed to do that. Now, the state of Utah can agree to go along with stuff, but they're not required to participate in enforcing federal acts or regulatory programs. All right, here's a juicy one. The Salt Lake Tribune editorial board says Utah leaders want to fight the Civil War over again. It won't end well, because just not participating in enforcing a federal program or just saying we are going to consider this at some point in the future means this is civil war. They hate the idea of anyone not going along with centralized power and control. I hope you guys found this interesting. I hope you enjoyed watching or listening as much as I enjoyed sharing this information with you. And absolutely nothing helps us do this kind of work more every single day, more than the financial faith and support of our members. Please consider joining us for as little as $2 a month over at 10thamendmentcenter.com/members. I won't belabor the point, but I'd really be grateful for any consideration you can give. We'll get the blog post published for this episode in a couple of hours over at 10thamendmentcenter.com/path to liberty. I hope you enjoyed the episode. I hope you have an awesome weekend, and I hope to see you next week here on the Path to Liberty.